Good day to you. I want to talk to you about communications in writing and electronic signatures today. In the recent case of Spring Forest Trading versus Wilbury, the Supreme Court of Appeal considered the issue of whether an existing contract could be cancelled by way of an exchange of emails between the parties. The matter arose because the contract contained a clause that specified that any cancellation could only be effective if it was reduced to writing and signed by both parties. And in the circumstances considered by the court, the parties had in fact exchanged emails in terms of which they did in fact agree to cancellation of the relevant contracts. The issue that the court dealt with specifically was whether the exchange of emails could be considered to be in writing and signed. The court considered for this purpose the provisions of the Electronic Communications and Transactions Act No. 25 of 2002 and found that the emails did satisfy both of those requirements. Where a signature is required by law and the law does not specify the type of signature to be used, Section 13(1) of that Act says that this requirement is met only if an advanced electronic signature is used. In dealing with the requirement for signature in this particular case, the court held that the burdensome requirements of advanced electronic signatures under that Act don't apply to private agreements, but only apply when a statute or a law requires a signature. The court also held that the typewritten names of the parties at the foot of the emails which were used to identify them were sufficient to constitute electronic signatures in terms of that Act. The case includes a brief discussion on how the courts generally approach signature requirements. They said this is a person's name written in a distinctive way as a form of identification. But the court also stated that this isn't the only way that the law requires a document to be signed. The court pointed out that in the days before electronic communications, courts were willing to accept any mark made by a person for the purpose of attesting a document or identifying it as his or her own act, and that was considered a valid signature. So the approach of the courts is pragmatic, not formalistic. They look to whether the method of signature actually fulfills the function, whether it authenticates the identity of the person sending the communication, rather than insisting that some specific form of signature be used. Now, we know that email is used for the purposes of communication between trustees, owners, and managing agents all the time. Whether the message is by email, SMS, instant message, WhatsApp, Twitter, whether it's posted on Facebook or elsewhere, if it's a communication by means of a data message, then it is an electronic message for the purposes of Section 1 of the ECT Act, and it is therefore considered to be in writing. So when you initiate any form of digital communication, bear in mind that you are communicating in writing. And if you add your name in any form whatsoever, you may in fact be held to be signing the document. To summarize, the Sectional Titles Act caters for many situations in which the communications must be in writing. Both the definitions of special and unanimous resolutions are examples, when these are to be taken by the round-robin procedure, and for these and in other instances in which the Act or the prescribed rules require that the communication must be in writing, a digital message will satisfy that requirement. On the other hand, when it comes to signature, as far as I'm aware, there's nothing in the Sectional Titles Act that specifically requires signature in regard to any Scheme Management Act. But in the prescribed management rules, PMR 24, 27, 38 and 40 all cater for signatures. In the first instance, it's when trustees take a round-robin resolution. In the second, in order to make a document valid and binding on the body corporate, it must be signed by certain people. In the chairman's signature of the trustee's annual report, and finally in the auditor or accounting officer's signature of the financial statements. But here, because the signature requirements aren't set out in the Act, but in the scheme rules, it's my view that the informal signature, given when you digitally sign, not a formal one, but just an even typing your name at the end of an email, constitutes a valid compliance with those requirements. Thank you for joining me in this Paddocks Club video tutorial. If you have any questions in this regard, please raise them in the discussion forum.